Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll put it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you was just a fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. I don't fucking take smoke, I'ma poke a hole through you. Choking's overdue. Come at me and you won't get any older, dude. Crack your holder too. Heating up inside of me, blood so violently. Thanks for trying me. Now it's finally time to see how this rivalry becomes a dynasty. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll put it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you was just a fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back.
Hello. How you doing? Hold on a minute. Let me fix something here. God, I hope this is working. All right, we got Lori Vallow in court today as her own attorney. Yes, her own attorney. Hold on a minute. All right. Let's get to this. I'm going to put this on mute. All right, let's go through this real quickly. All right. There we go.
Inmate Legal Services works. Did you receive the state's response yet?
I did receive it yesterday, but I was hoping that I could put my response on the record today, my reply.
That's fine. Go ahead.
Ready?
Yeah.
Okay. Oh, let me get my glasses. Do you want me to stand, Your Honor, or can I just sit here?
You can sit there.
So the state has claimed in their response that these documents are not material in the case, and this defense is entitled to this specific evidence for the proposition that this evidence can be used to impeach the thoroughness and good faith of the police investigation and the intent of the prosecution. That's Kyles versus Whitley, 514 U.S. The acid test of this prosecution is not a matter of determining if the defendant is guilty of the crimes that the defendant is charged, but rather, was any crime even committed? And where is this evidence? This defense has yet to find any evidence of conspiracy in the 100,900.
Okay, everybody, you pay attention. Lori Vallow. Do you hear that? Do you hear that tone? You go, Lori, you go. Oh my God! Come on now. It's 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 an argument, but not an argument, right? Don't argue to the judge.
139 pages that have been turned over by the state. The state does not get to say, like they did in their last motion to us, in their last answer, to say, oh, we gave you over 100,000 pages, so that ought to keep you busy. That's not how it works. These are serious charges, and these are serious consequences for these charges. In determining the actuality of a crime, the state is required to meet, in reality, not in theory, a standard of culpability that is defined by law as a crime. The state is required to meet the challenge of defense reasonably without bias, conflict, prejudice, or speculation. So the defense, we keep filing motions for discovery since we don't know if it's some kind of strategy of the state that they're holding back this actual evidence of conspiracy in hopes that the defendant won't have time to prepare a proper defense against the evidence that comes forward at the last minute. This court has denied every motion the defense has filed to acquire this evidence. The state has claimed in their response to the defense's motion that the defense's request is overbroad and wide sweeping. Is this the defense left to pinpoint where this evidence is and try to find it? No, that is not the law. The state is required by law to give the defense evidence of the crime they are being charged with. This is the purpose of the Brady Law and the right to due process. This is why in 2020, the United States enacted the Due Process Protection Act that provides defendants like me with greater protection, Brady versus Maryland. The state has continued to impede the defense from conducting a defense. This is a violation of the 14th Amendment of our great Constitution and the defense's due process rights. Today, the defense is requesting that this court do the following three things. One, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today. I would also ask that they would pare down their witness list to these witnesses that will actually be testifying so the defense can conduct productive interviews. And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay, and I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
What does anything in the extradition have to do with the underlying charges? Can you tell me that?
Yeah, it's to find out why all this started when I can't find any evidence that there is. So
have you read the grand jury transcripts?
I have.
Okay, the grand jury transcripts summarize what the state's evidence they intend to produce at trial.
I understand that.
So when you say you can't find anything,
Oh my God.
that is the summary
I'm sorry.
in the grand jury transcript.
Oh, this is not going to end well. Okay? This won't end well. She got an attitude her first time representing herself in front of the judge.
Transcripts.
Correct.
Okay. So I guess I don't understand how an extradition a year or so after the fact, after the indictments, would have anything to do with the underlying charges. So can you articulate that for me?
I can, Your Honor. There's the detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert. You have all these people. Then I have them coming on, and they're going to be on the stand, and they're going to be in trial, and they're going to be saying what they reviewed. They've reviewed all these things, and there's communications between all of these agencies that I feel like that the defense is privy to. We should be able to have that and look at that and see where all this came from, where all this started, why they waited 2 years to make these charges. There's all these things, and why they decided to extradite when I saw someone sent me a news article 3 days before I got brought to Arizona that MCAO was putting out a release that they were not going to pick me up and they were not going to extradite me to Arizona until after my appeals were finished. So it's contradictory to that. I just don't know where it came from. And there's a lot of things that are mystery questions to the defense that we are entitled to according to the law.
All right, well, everything you've just told me, none of that would be relevant in the trial in the case in chief. Does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime that have been charged in the indictments?
The state, although there is information that occurred after that will relate to the conspiracy that has been disclosed to the defense, anything that occurred after the indictment, during the extradition process is completely irrelevant and will not be brought in during the trial.
I didn't mean the date of crime listed in the indictment. I meant the date of the indictment.
Correct.
So the state doesn't plan on presenting any evidence to a jury of anything after the indictment.
Correct.
So how would that, anything to do with the extradition, be relevant to your trial then?
I feel like it's relevant to the whole, Your Honor, in the sense that the police investigation and the intent of the prosecution, it doesn't make sense. I would like to be able to have that.
All right. Are you otherwise on track for your trial date?
Correct.
Are there interviews going on with your investigator or your advisory council team?
We're working on getting those set up right now.
Okay. Is there anything else we need to address today? This was sort of just a status conference to make sure things are on track.
I have 2 motions that I'd like to file with the court today.
All right. Do you have copies for the state?
I don't today. I thought you could make a copy.
Can we see them?
Sure.
I'll ask the deputy county attorney, from your perspective, anything we need to discuss here today? Yeah.
No, Your Honor.
How long, I'm assuming the 2021 case would be the case that the state intends to try first.
Correct.
How long would that case take for the state's portion to present?
Probably a couple weeks, Your Honor. I mean, and I say that obviously I'm unaware of how long defense will take for cross-examination. So I would probably ask to pre-screen the jury for significantly longer than that.
Meaning 3 weeks or 4 weeks?
Yes, Your Honor. I obviously, I do not know what Ms. Daybell is going to question any of the witnesses.
As we're looking toward that trial date, is advisory council willing to assist the defendant on the jury screening process if we do the electronic questionnaire?
Yeah, to the
Okay.
extent that we
All right, good.
going outside of our scope, but yes.
Sure. I have received a motion for specific discovery from the defendant, well, 2 separate ones. Just going forward, can you title them maybe what specifically you're looking for? Because if you name all your motions the same thing, it gets a little difficult to keep track of them. But I have 2 separate motions for specific discovery.
Just like discovery.
For example, on this one, you could title it something like motion for discovery related to the Gilbert DR number or something like that, just to differentiate these. We'll make copies of these for the prosecutor and then we'll have those filed with the clerk today. One of your requests was to have the state send you directly any pleadings, which according to their mailing certificate at the back of the pleadings, they are mailing them to you. I can't do anything about how long the jail takes to process that. So I do recognize that there's probably some delays on that, so we won't hold you to the normal reply times because of those delays that it takes getting through the jail administratively. All right.
In that case, Your Honor, could we have perhaps that go to my investigator, then I could maybe get those faster? Can he also be included on that?
Your Honor, I do email them to advisory council as well as in the court, so.
All right.
But there's not much else I can do.
Who's your investigator?
Jeff White.
And your advisory counselor in contact with him? Yeah.
They can be.
Okay. So the record will reflect that the state's getting a copy of those two motions today, and then the state will respond accordingly. I'll just set a I'll have you reply within 10 days of the date of the filing of their response. All right. Depending on what and then I'll rule on the motions as they come, or I'll set a hearing if need be. But at this time, I'm going to affirm the final trial management conference of March 18 at 8:30 a.m. in this division. Trial date's currently March 31. Again, the first case that would be heading to trial would be the 2021 case. Anything else for today?
Yes. Will trial be staying before Your Honor? And if so, will we be staying in this courtroom?
I don't know yet. I'm going to confer with the associate presiding judge, and I suspect it will stay here and it will stay in this courtroom, although for jury selection, we may move to a bigger courtroom if we're doing in-person voir dire.
And Judge, I do know there will likely be the next of kin present. This courtroom obviously does not have a victim room or a witness room. With the media, that obviously makes it more difficult for the state to keep those individuals away from each other, from overhearing each other in this type of case. So obviously, we're happy to stay before this court, but would be requesting that this be reset or moved to the South Court Tower so we would have those accommodations.
I'll talk to the criminal presiding judge and the associate presiding judge regarding that. And it's just a matter of availability of bigger courtrooms. Anything else from the defendant?
I just was going to ask, can we set both trial dates, or how are we going to do that?
You'll have two separate jury trials with two separate juries.
Correct.
So the first trial that will be on or around March 31st. We anticipate when that trial's done, we'll talk about how quickly we're going to do the second trial. Does that answer your question?
Somewhat, yes.
Okay. It's hard to set the second one without knowing how long the first one's going to take, and then the readiness of everyone as far as the second one after the first one concludes. All right, we will be at recess on that matter. I'll take any motions under advisement.
Lori. Okay, that was interesting. Let's look at that ring. Let's look at the ring. She got a little attitude in there, didn't she? Hold on a minute. Oh, shoot. I'm going to have to take a screenshot. Hold on a minute. Okay. Now, peoples. This is going to be good. This is going to be good. I hate to say it. She got an attitude already with the judge. Hold on a minute, please. Hold on, hold on. Okay, sorry. Sorry about that. So yeah, this is going to be interesting. I think even more interesting than if Letitia. Hold on a minute. We're going to watch this. If you guys want to, hold on a minute. I'm sure a lot of people probably don't care about this, but I'm kind of interested in what's going on with TikTok. I was watching the Supreme Court today.
Supreme Court.
Good afternoon, everyone. My name is Noel Francisco. I'm a partner at Jones Day, and I'm proud to represent TikTok Incorporated and ByteDance Limited in this important First Amendment case. We thought that the argument went very well. The justices are extremely engaged. They fully understand the importance of this case, not only for the American citizens of this country, but for First Amendment law generally and the rights of everybody. We thought that they vigorously questioned both sides. They put us through our paces, but what really came through is that they understand the importance of this case. We're very hopeful of a favorable decision. I'd just like to emphasize a few points that came up during the argument. First, and perhaps most importantly, TikTok Incorporated is a United States company. It's incorporated in the state of California. It's got thousands of employees based here in the United States. The government does not dispute that it is a bona fide U.S. subsidiary operating in the United States in accordance with all of the applicable principles of American corporate law. Second, ByteDance Limited is a private company. It is a private holding company that is based in the Cayman Islands. It is not owned by China. No arm of the Chinese government has an ownership stake directly or indirectly in TikTok Incorporated or ByteDance. ByteDance, rather, is 58% owned by global institutional investors, including very large American institutional investors like Susquehanna and General Atlantic. It is 21% owned by its employees, many of whom are American employees here in the United States, and it is 21% owned by one of its founders, who is a Chinese national living in Singapore. Third, TikTok Incorporated exercises independent judgment with respect to the algorithm in the United States. The source code for the algorithm is brought into the United States and stored on servers located in Virginia. There, it's converted into executable code, it's modified, it's customized, it's trained, it's moderated pursuant to moderation policies, and it's implemented in the United States. So when TikTok Incorporated implements the recommendation in the United States, that is very much TikTok Incorporated's speech. That is the speech of a US entity speaking in the United States. Fourth, the intellectual property for the algorithm is not owned by the Chinese government. It is owned by ByteDance Limited, which is a global entity, a company that is incorporated in the Cayman Islands and operates through subsidiaries throughout the world. And then my final substantive point is that the United States government concedes that it has no evidence that China has ever attempted to date to control the US TikTok platform. It concedes that China has not attempted to censor content on the platform in the United States. It concedes that China has not attempted to misappropriate user data in the United States. And if China ever asked TikTok or asked TikTok through ByteDance to do any such thing, it would refuse. I think what we heard today in oral arguments, when all of the lawyers were up, were the important First Amendment principles at stake here. We're talking about a social media platform that is regularly used by 170 million Americans. That is half the country. This country has never taken the step of shutting down a speech platform, much less such an important speech platform, because, as the government effectively concedes in its briefs, it's afraid that the content that could come out on that platform might be, dangerous. We don't normally think of speech as dangerous. The Supreme Court has repeatedly said speech is not dangerous. And you don't shut down a speech platform because you're worried about speech being dangerous. That is the whole point of the First Amendment, that we engage ideas with ideas and we let the truth come out. That's the fundamental problem with this act. It doesn't reflect the trust that the First Amendment places in the American people. We are confident that the Supreme Court will place that trust in the American people, and we look forward to a favorable decision out of the court. I'd now like to introduce my colleague and dear friend, Jeff Fisher.
Thank you, Noel. My name is Jeff Fisher. I'm a lawyer, a special counsel at O'Melveny & Myers, and I represented the creator petitioners in this case. So I'll start with where Mr. Francisco left off. This is an unprecedented case. I don't think there's any way to think about it in any other fashion. The government has never threatened to shut down a speech platform in this country because of the ideas expressed on that platform. And so the point of the creators here and their participation in this lawsuit is to absolutely drive that point home and remind the justices and remind the public that this case is at core about Americans speaking to other Americans about everything from everyday life to current events to anything else they care to express themselves on this particular platform about. And that is a most cherished freedom in this country. Another way to think about this is creators expressing themselves in all sorts of ways, whether it be with words or art or music or anything in between, have a right to choose under our First Amendment what publisher is best for them, what editor is best for them. A journalist can publish in a particular magazine because they like the leadership and the owners of that magazine as opposed to someone else. A music band can post their music on a particular platform or play in a particular venue in a particular city because they find that that expresses their art the best. Any number of other permutations that you can imagine. We don't have any decision ever from the United States Supreme Court that has ever restricted the right of a creator, a speaker in this country to express themselves through collaboration with publishers and editors against their own wishes, that they can be overridden in that sense. And it doesn't matter whether we're talking about purely American collaborators or whether our American collaborators have also foreign corporate entities to which they are related as well. Whether it's the BBC, the CBC, or NPR, people can choose to express themselves on whatever platform they wish, free and clear of government interference, particularly when the government's reason for interfering. And I think this is where we take heart from the hearing today. When the government's reason for interfering is we don't like the viewpoint or the content that's going to be expressed through that platform. That is the core First Amendment value that our framers enshrined in the very First Amendment in our Constitution to protect freedom of thought, freedom of expression, freedom to create, freedom to share, and freedom to learn from other people. That leaves the only other thing the government had to say in court today, which is that this act could somehow be sustained solely because of data security concerns that have been expressed in various ways in various legislator statements. We just don't think that's correct. And so one thing I'd like to emphasize is that whatever data TikTok has from users by way of that relationship, that creator-publisher relationship, is no different from the data that creators would give to Instagram, YouTube, any other platform to express themselves on. There's no difference between the data in one place versus the other. And also, the data that's shared is done so on a voluntary basis. So one of the justices today expressed the concern about paternalism that comes from the government in this case, whether it be to protect us from ideas or to protect us from choices we might make to best express ourselves and share data about ourselves with our publisher. We think that's our choice to make. It's not the government's decision or its right to make that choice for us. So today, and perhaps the main event, is that I have 5 of the creator petitioners here with me today. And I really think it's important for you to hear from them because that's the face of this case, certainly from the American creator perspective, are the people that find TikTok an invaluable resource for self-expression, communication, and exchange of ideas. And so I'm going to introduce them and let them come up, I think, one by one and introduce themselves to you and then be available later. So their names are Chloe Joy Sexton, Topher Townsend, Paul Tran, Stephen King, and Tim Martin. These are 5 of the 8 creator petitioners in this case that were before the court today, and I believe most, if not all, in the courtroom today. So I'll let them come up in whatever order they wish and introduce themselves to you.
Hello, everybody. My name is Paul Tran. I want to first thank the Supreme Court for hearing our argument today. As co-founder of Love and Pebble, a small business built on the foundation of American entrepreneurship, I pray that the Supreme Court of America does what is right in protecting us. This isn't just about our business. It's about our fundamental right that makes our nation great. Our story embodies the American dream. My wife and I built Love and Pebble from the ground up using TikTok to share our passion and connect with people, with Americans all across the country, something no other platform has allowed us to do. I have a 2-year-old daughter, and when I look at her, I think about the America I want her to inherit. Do we want to teach the next generation that the solution to our challenges is to restrict freedom rather than protect it? Do we want to show them that it is acceptable for the government to decide which platforms Americans can or cannot use to express themselves and build their businesses? The First Amendment isn't a relic of the past. It's a living promise that must be defended in this digital age. By banning TikTok, we're not just removing an app, we're setting a precedent that threatens the very freedoms our country was built upon: free enterprise, free expression, and the freedom to innovate without unnecessary government intervention. Love and Pebble stands here represents more than just my family's dream. It represents the dreams of countless Americans and entrepreneurs who deserve the right to choose how they reach their customers and share our stories, real American lives. There must be a solution that protects both our national interests and our constitutional rights. My daughter deserves to grow up in a country where entrepreneurship thrives, where speech remains free, and where the government protects rather than restricts our constitutional right. The America I believe in doesn't shut down platforms for communication and commerce. It innovates, it adapts, and it finds solutions that preserve both security and liberty. That's the America I'm fighting for, and that's the America I want my daughter to inherit. So I pray that the Supreme Court hears the voices of myself and the millions of Americans. I pray that they protect our First Amendment right to use the platform of my choice, and I pray that they save TikTok. Thank you. Chloe, you want to go next?
Hi, I'm Chloe Joy Sexton, and I'm a plaintiff in this case from Memphis, Tennessee. In 2020, I was fired from my job after telling my employer that I was pregnant. I was also struggling to care for my mother, who I eventually lost to brain cancer. I then began raising my 7-year-old sister. I started creating TikTok videos to financially support my family and as a creative outlet where I discussed everything from parenting and grief to my love of baking. I could never have expected the outpouring of love and support from the community on TikTok. My videos went viral and allowed me to jumpstart my business, Chloe's Giant Cookies. I have now shipped thousands of cookies all over the world and even published a cookbook. As a small business without a lot of capital, I rely almost entirely on TikTok to market my products. To say TikTok changed my life is an understatement. TikTok is the place where people told me I could do so much more with my life than I ever believed. I'm a plaintiff in this lawsuit, not just for myself, but for all of the women who, through TikTok, found their dreams and financial independence while taking care of their families and their children. A TikTok ban would place these women, including myself, in true financial jeopardy. It would destroy both my business and the community that means so much to me. No other platform can replace it. I have tried posting the same exact content on other social media apps without anywhere near the same success. I thank the Supreme Court for hearing our argument today, and I hope that the justices will protect my First Amendment right to continue to use the platform of my choice. Thank you.
Hi, everybody. My name is Topher Townsend. I'm a plaintiff in this case from Philadelphia, Mississippi. I served in the U.S. Air Force and now run a nonprofit called Stay Anywhere Ministries, dedicated to promoting knowledge about the Bible. I also work as a hip hop artist, focusing on topics such as faith and patriotism. So I started creating TikToks back in 2019 as a way to creatively express my political views and to share fun facts about the Bible. I found TikTok to be a much more civil platform for discourse about important issues than other social media apps, allowing me to build a community and exchange ideas. TikTok is also an unparalleled platform for collaborating with other musical artists and promoting my music. My music really took off after I started sharing it on TikTok, even though I've been sharing to other platforms for many years previously. I largely credit TikTok with the fact that my music has been streamed over 100 million times, and I've climbed the Billboard charts multiple times, even achieving a #1 Billboard hit with my song, The Patriot. See, the streams mean income for my family, and the joy of knowing my music is reaching people around the world. See, without TikTok, I would lose an important platform to share my views and engage with others in a way I have not been able to do on other social media sites. And my 2.6 million followers around the world would also lose access to vital content related to faith and current events. As a veteran and American who values free speech, I find it disturbing that the government is closing a form of expression for so many Americans. This ban betrays the values that I sought to protect while serving in the armed forces. I thank the Supreme Court for hearing our argument today. I hope that the justices will protect my First Amendment right to continue to use the platform of my choice. And last but not least, we are not for sale. Thank you.
If any members of the media would like to speak with any of our creators to set up individual interviews, please let me know. Otherwise, thank you for coming.
All right. So there's that. Okay. Hold on. Let me get this out. Okay. I will say this about TikTok. TikTok silence certain people, certain subjects as they find fit. They don't like anything to do with true crime. I can tell you that much. They make up new rules, like not rules. Okay, for like terms of services. Okay, they'll change it how they see fit. Like there was a new one. What was the new one that just came out? Well, let's see, with the drones that came out, stuff with the drones that came out. There was something about that. I actually got a strike for a drone video. Let's see what else. Oh, of course, Luigi. Okay, anything to do with him. Okay. So I don't know. You're silenced anywhere you go. Not really silenced. I shouldn't say it like that. Hold on a minute. Someone's at my door again. Sorry about that. Someone's at my door again. What's going on? My dog's going to go nuts. Anyway, so there's that. I don't know what you guys think about TikTok. TikTok is really good in the sense of getting information out there like really quick. But it's just like any other app. It really is. All right, I'm gonna go for now. Yeah, so Lori did such a fabulous job tonight representing herself. She gave a little attitude with the judge and the state, so this should be good. Hey, girl, how's it going, girl? But I'm going to go for now. All right, talk to you later, Misty. Goodbye, everybody. Who all came through? Bogart, AP, Misty, and anybody who watches the replay.